Viewers, greetings. We all know that NCLAT principal bench was on vacation, summer vacation, for the month of June, and it opened on 30th of June. In between, Chennai bench was open, but uh, Chennai bench being a much smaller bench, the number of verdicts were less. Supreme Court is also on vacation till possibly 15th of July. So in between, we had done some videos based on topics. This particular video is on the judgments which came out during the vacation period from Chennai bench and after NCLAT opened, the principal bench opened after 30th of June. So with this, we take you over to the next part of the video.
Viewers, you can see Guide to IBC on your screen. Now, we have essentially, as I said, we are essentially going to discuss on about 10 cases which happened during the NCLAT vacation period. So they essentially pertain to judgments of Chennai bench and some are of Delhi bench, that is the principal bench, between, say, yesterday and so on. So first we are going to move according to sections. So first case what we are going to take up is pertains to section 3. So let us move to section 3. Section 3, subsection 6, claim. Topic 2. Now, this case is Vinod Thakkar versus Narendra Kumar Sharma, RP, in which it is an NCLAT observed that before rejection, each claim needs to be thoroughly examined on its merits. Now, this was a group of claims from home buyers. And the RP had checked the claim and he found that on the CRM of the corporate debtor, the names of the buyers were not there. But though it was a fact on checking of the bank account, it was found that the money was received from buyers. But since there were some faults with other applicants, there were some false claims and things, RP said that since CRM is not corresponding, the claims are rejected. When it went to adjudicating authority was of the same opinion as the RP. But what NCLAT said is that before, because one claim may not be the same with the other. So each claim should be checked individually and then it should be rejected. So this will also appear in Regulation 13 CIRP. Because these are home buyers, and as we all know that home buyers are considered as financial creditors. So this comes under verification of claim, of financial verification of claim. So this will go under Regulation 13 as well. Now let us go back to section 3.7. Section 3.7 pertains to corporate person. Now, this is an interesting case of Gagan Chhabra versus SMS Vishwa JV, etc. Now, in this, NCLAT was of the view that no application under Section 9 or for that matter 7 or 10 of IBC can be filed against an unincorporated entity. Now, if we look into 7, what is a corporate entity? Corporate entity is a company, is a corporate person with, as defined under Clause 20 of Section 20 of Companies Act 2013. Limited liability partnership defined under so and so. I mean, it is essentially corporate. Now, in this particular case, what happened was it was a JV of 3 companies, of which 2 had already gone into CIRP. And the claim was the claim was filed initially against the lead of the JV, and the claim was rejected. But the claimant did not pursue that rejection. Instead, he filed a claim against the JV. So NCLAT was of the view that no application under Section 9 or for that matter 7 or 10 of IBC can be filed against unincorporated entity. Now, let us move to another interesting case that is of, as a matter of fact, of yesterday, if I'm not wrong. Now, this is a new topic. This is a huge case. This judgment is of 41 pages, which we have extracts are, of course, much less. Now, this is Edelweiss versus Takshila Heights India Private Limited. Now, what NCLAT said, the basic takeaway is there is no legal embargo or bar upon a creditor to initiate CIRP subsequent to the initiation of recovery actions by the creditor before DRT or SARFACI or before any other forum. Now, the basic point is that creditor is at full liberty to initiate recovery action in any forum he wants. But so long that forum, the final judgment hasn't been reached. In such case, petition under Section 7 or petition under Section 9, whatever it is, herein it is 7, can definitely be moved. And NCLT can definitely entertain such a petition. This, of course, this was held earlier also in another case, but this is a new topic, so it becomes important that I tell you. Now let us move to another one of Section 7. Now, this is of Swaminarayan Diamonds Private Limited versus Canara Bank. Now, what NCLAT said that ongoing failure to meet repayment obligations justifies initiation of insolvency proceedings. Thus, changing of date of default may be permitted. Now, herein, Canara Bank had changed the date of default. NCLAT referred to the judgment of Dena Bank and said that therein Supreme Court had said, so long limitation is not getting affected, till the adjudicating authority arrives at the final verdict, the financial creditor or the parties, the financial creditor can always bring in something new or they can bring in additional pleadings. There is no embargo on that. And in Swaminarayan Diamonds, Canara Bank had changed the date of default, which did not actually alter the basic fundamentals. So the court said no illegality appears to have been committed by the adjudicating authority in giving liberty to the appellant to submit amended form number 1. More so, when a consequential opportunity has been given to appellant to file a reply or response with regard to amended form number 1. And NCLT had told the respondent also, while this is getting changed, you can submit your reply to that as well. So there was no infringement of the principles of natural justice. Now, let us move to another case. It pertains to Section 12A. This case is of yesterday. Now, in the absence of any claim made by the creditors, other than the one who have filed the application under Section 7, even though due publication was made by IRP, NCLAT can exercise jurisdiction for settling the dispute between the parties. This was held in the case of Gaurav Bhatia, suspended director versus Preeti Bhatia. There are actually two cases. Now, in this case, what happened was Section 7 came in. The corporate debtor agreed to repay the debt in entirety. And NCLAT had issued issued a stay order. But before the stay order was issued, IRP had uh, published the form 1, but no claim was received. So NCLAT was of the view that 12A, it could very well have the jurisdiction, considering the judgment in the case of Glass Trust of Supreme Court versus Baiju Ravindran, it opined that even if there is, NCLAT does have jurisdiction to settle the dispute between the parties and direct NCLAT to consider the 12A petition. So NCLAT did not admit the 12A petition. It directed NCLAT to consider the 12A petition. Now let us move to a very important topic. This, of course, is appearing in 32A. It is appearing in section 67, but we'll straight away go to section 233. Because this essentially this pertains to 233. Now, this is a Supreme Court judgment in the case of Ashwini Kumar Govind Bhai Prajapati versus State of Gujarat. Supreme Court observed that subjecting the counsel in a case to the beck and call of the investigating agency or prosecuting agency or police prima facie appears to be completely untenable. However, the matter was referred to Chief Justice of India to decide finally. But this was the view of Supreme Court. So this is a kind of protection also which may be applicable with respect to insolvency professionals if they are acting as IRP, RP, or liquidator. Well, I am not an adjudicating authority, I cannot say. But this essentially pertains to an advocate. But we are also, in a way, public servants. So this should apply to us as well. And hopefully, Honorable Chief Justice of India will take a view on this. So this is a very important case, in my opinion, and that is why I shared it with you. Now let us move to section 42. Now, before we go on to the case, let us look at section 42. A creditor may appeal to the adjudicating authority against the decision of the liquidator, accepting or rejecting the claims within 14 days of the receipt of such decision. Here, 14 days is important. Now, in 42, what was a creditor may appeal to adjudicating authority against the decision of the liquidator within 14 days of the receipt of such decision, post which it will be barred by limitations. This was held in the case of Joint Commissioner of Commercial Taxes versus Srimati Anuradha Bisani by Chennai NCLAT. That 14 days is the limitation period. Beyond that, if you apply, it is not permissible. It is barred by limitation. Now let us move to section 61. Topic 52, I think. Yes. It says that it was held in the case of Sandeep Kasare versus Somerset Estate Private Limited. It says that as per Rule 26, Sub-Rule 2 of NCLAT Rule, 7 days are prescribed for refiling of appeal from the date when registry intimates the defect to the appellant. So 7 days is the limit. If you delay beyond that, the delay will not be controlled. We know that there is a term of from NCLT order, there is a 30 days and 15 days can be considered. But this pertains to defects. And for defects, both in NCLT and NCLAT, the time permissible is 7 days, within which it has to be corrected. Else, it will be barred. NCLAT or NCLT may not accept any pleading thereon. Now, let us move to individual insolvency. 99. Topic 10. This is also a case of decided by Chennai NCLAT, in which it says that complying with the conditions of providing a time period up to 7 days to file the information under Section 99, subsection 5 of IB Code 2016 is mandatory for a resolution professional. In this particular case, what happened was a personal insolvency was initiated. The resolution professional was appointed. He sought for information, but gave only 2 days time. Thereafter, he gave a reminder after about maybe 15 or 20 days. But then court asked him, when did he compile his report? It was found that within 6 days he had done that, 5 or 6 days. So court was of the view that no, that was wrong. The section compels him to give 7 days time. And if that is not done, the report is prima facie not acceptable. It is a mandatory requirement. We come to the last judgment, which it is under 115. Repayment plan having not been submitted by debtor, natural consequence was creditor to file for an application of bankruptcy under Chapter 4. This was done in the case of Mr. Nasir Ahmed versus Ravindra Belaur, in which it had earlier also happened that consequential decision taken under Section 115(2) by learned adjudicating authority would permit creditors to file application for bankruptcy by invoking the provisions under Chapter 4. So it is the duty of the personal guarantors to file the repayment plan. If they do not file it, it is to be construed to be rejection of repayment plan. And NCLT has got power to pass an order under Section 115, and in which case NCLT and the creditors can initiate bankruptcy proceeding under Section 121. If we come to 121, the consequential decision taken under 115(2) would permit the creditors to file its application for bankruptcy. This is held in the case of Nasir Ahmed, as we discussed. So, viewers, we almost come to the concluding part of this podcast. The main takeaways of these judgments, 10 judgments, which I explained, I do not call any judgment, I call all judgments as landmark judgments, because there is something new or the other. These judgments happened during the time when NCLAT principal bench was on vacation. Chennai bench being a smaller bench, the judgments are comparatively less. However, during this period, some judgments did come out, but due to paucity of number of judgments, we basically concentrated on topic-wise podcasts. Now, what are the main takeaways? Firstly, what we saw that NCLT cannot reject claims, a group of claims. Each claim has to be checked based on its merit. Number two, what we saw is that that no application under section 9, 7 or 10 can be moved pertaining to a party, corporate debtor, pertaining to a debtor who is not a corporate entity. That means you cannot move an insolvency against an unincorporated body. Then we came across a judgment in which it says that there is no legal embargo in moving Section 7 application, despite recovery proceedings having started under DRT, SURFACE, or any other law, so long the concerned court has not reached a final decision. Then we came to the topic of the fact that changing of the date of default till NCLT comes to a final verdict is permissible. This was held in the case of the NCLT referred to Dena Bank judgment and said that the changing of the date of default is possible, so long it does not interfere with the limitation. Then we came to a judgment in which it said that claims made by it said that NCLT has got jurisdiction. Though going by class trust judgment, NCLAT does not have jurisdiction to give verdict on Section 12A. But NCLT has jurisdiction to resolve a dispute between two parties and recommend NCLT to initiate proceedings under Section 12A. Then another important Supreme Court observation we saw that subjecting a counsel or a service provider to a corporate debtor cannot be hauled by investigating agency. Though the matter has been forwarded to the Chief Justice of India, but the Supreme Court held that this kind of hauling or calling counsels or is incorrect. We also came across the concept of rectification of defect. It says that as far as NCLT rule and NCLAT rule, if a defect is pointed out, it has to be cured within a period of 7 days. We also found that in personal guarantee insolvency matters, with regard to personal guarantors, under Section 99, an insolvency professional or the resolution professional must give 7 days time to the personal guarantor to seek information, to obtain information. If it is not given, then the court can outright consider the verdict or the opinion expressed by a resolution professional, outright reject it. And lastly, we found that if a repayment plan is not filed by a personal guarantor, then it is considered, the court, NCLT can consider that it as a rejection of repayment plan and naturally issue an order under Section 115, which will give right to the creditors to initiate bankruptcy against the personal guarantors. So with this, we come to we move to the next part of the video. Hope you enjoyed it. Thank you.
Viewers, I hope you have enjoyed the podcast. But before ending, I was just, checking whether I have missed out any judgment or not. And I came across one judgment, and I cannot refrain myself from telling you about it. It is the case of Government of Tamil Nadu versus N. Ramachandran. And this is a wonderful judgment, and which is delivered keeping in view the Supreme Court judgment in National Spot Exchange. There, in this particular case, the liquidator had collated claim. He was the he was the RP, and Axis Bank was the COC, main COC member. The company went into liquidation, and once the liquidation process started, while the liquidator was trying to initiate the auction process, the liquidator observed that one particular asset had an encumbrance. That is an attachment by GST authorities. He moved to NCLT to remove the attachment, and GST authorities wanted to recover they had filed claim under with Form C, and they wanted to recover their security interest by way of Revenue Recovery Act 1864. Now, NCLAT gave a wonderful judgment stating that lifting of the attachment hastens the process of settlement of dues of the liquidator. The lifting of the attachment also goes in consonance with the very purpose of attachment under provisions of the Revenue Recovery Act. The liquidator, if he does auction, he recovers money and he pays. So the very purpose of attachment is served. The lifting of an attachment is not dehorse the interest of the appellant. Since GST authorities have already raised its claim, it cannot simultaneously press upon the claim for recovery of taxes due by continuance of attachment of the asset of the corporate debtor. This is something like you cannot have the cake and eat it also. And this is a wonderful judgment. That means the statutory authority, having raised the claim, they cannot simultaneously press for recovery. And this, because why? If you go look at section 33, subsection 5, one cannot initiate any proceeding which would harm which would cause which will be detrimental to the interest of the liquidation estate. And even section 238, it says that IBC prevails over other laws. So this takes into account and says that if a statutory authority has raised any claim and at the same time has an attachment, they have to remove the attachment for the interest of the liquidation, or rather auction and sale of the assets. With this, we come to the end of the video. We hope you enjoyed it. Thank you.